Hi, and thank you for visiting the website of the Texas Laser Institute. My name is Robert Logue, and I am the president and the dean. I'm oftentimes asked, particularly as a lawyer, about the rules and regulations that are applicable to our industry, and particularly that of the new rules and regulations pertaining to laser hair removal. So I want to take a few moments and discuss this with you. First and foremost, it's important to distinguish between Rule 301 and Rule 302. Rule 301 is the old rule, essentially that which applies to physicians, their practices, and those individuals to which they delegate laser hair removal treatments to. However, the vast majority of individuals, particularly those that come through a 40-hour state-approved training program, fall under Rule 302. So let's take a few moments to discuss what that registration process entails. So let's first talk about the individual, or you. So what do you have to do in order to perform laser hair removal treatments in a 302 environment? Or in other words, a facility that's not wholly owned by a physician that has incorporated laser hair removal into his or her larger medical practice. Well, as an individual performing laser hair removal treatments, you have to understand that there's 4 different levels of registration. You have the first level, which is the technician, apprentice, and training. The second level, which that is of the technician. The third level, which is a senior technician. And then finally, the fourth and the highest level of registration, and that is that of a professional technician. So let's go ahead and take them in turn. How do you first become a technician, apprentice, in training? Well, you have to go through a state-certified or state-approved 40-hour laser hair removal training course. The Texas Laser Institute is certainly one of them. We are currently one of the busiest colleges in the Houston marketplace, as well as throughout Dallas with the opening of a brand new and second location. After your course, you're now able to be called a certified laser hair removal technician underneath DSHS. So in essence, we certify you as a laser hair removal technician, and then DSHS will then register you as a certified laser hair removal technician. But that's the first step, to go through the 40-hour program, become certified as a laser hair removal technician, and then become registered through DSHS as a certified laser hair removal technician, albeit an apprentice in training. As an apprentice in training, or the first step, you're able to perform laser hair removal treatments in the state of Texas, but only underneath the direct supervision of either a senior or a professional laser hair removal technician. That is to say, either a senior or professional hair removal technician must be in the room with you while those treatments are being conducted. A lot of individuals see why they'd want to upgrade their registration for that reason to at least that level of a technician. That way you do not have to have a senior or professional technician in the room with you at all times. So how do you do that? Well, you have to complete 100 treatments. It's not as hard as it seems though. While the state regulations identify or define the body into 4 quadrants, meaning that you could literally treat an entire body and it only count as 4 body areas or 4 treatments, DSHS has interpreted that differently, such that smaller areas such as the chin, upper lip, center eye, jawline, cheeks, sideburns, front neck, back neck, ears, nose, all these areas can encompass a different type of treatment. As DSHS believes, and as it is correct, different body areas, despite how closely they may be in proximity to one another, can certainly possess different characteristics of hair, as well as different melanin content within the skin, and as a consequence must be treated with various considerations and possibly different treatment settings. So for that reason, you're really able to take the treatment settings down to a very micro level. With one individual, for instance, you can easily treat over 25 to 30 areas. So you can see you can accomplish 100 treatments in a single day with an appropriate laser system with just about 4 or 5 individuals. But upon doing so, upon completing your 100 supervised treatments as signed off by a senior or professional technician, you're then able to upgrade your registration level to that of a technician. The cost of doing so is $70 with an application sent in to DSHS. Once you're a technician, if you'd like, now you can perform laser hair removal treatments without the direct supervision of either a senior or professional technician in the treatment room with you. A real good sense of freedom, if you will. Also, on top of that, a lot of clients don't want our professional technician on site. So with that being said, a lot of individuals like to upgrade their registration still to at least that level of a senior. So how do you do that? Well, to become a senior technician, all you have to do is quote-unquote supervise 100 treatments. Well, who can you supervise? Well, it's a little bit ironic, but you can supervise really anybody that is registered to perform laser hair removal treatments. So it could be another technician, another apprentice in training, a senior technician, or even the professional technician that just got finished supervising your first 100 treatments. So the law doesn't specify, so DSHS allows you to supervise any level at that time. But I caution you, if you're going to supervise a technician apprentice in training, remember that individual must be supervised by either senior or professional. So at that time you're going to have 3 people in the room, the technician apprentice in training to whom you're supervising, as well as either senior or professional to provide the necessary oversight for the apprentice in training, the one that's performing the treatments. So that will allow you to become a technician at the senior level. Then finally, if you'd like to become a professional technician, all that's required is that you complete the certifying examination through what's called a state-approved certifying entity. Now the Texas Laser Institute is also a certifying entity, and we administer the professional examination. It comes along with a 4 to 5 hour review course. For individuals that have taken that review course previous or prior to the examination, we have about a 99.5% passage rate. In addition to that, the 4 to 5 hour review course is also 4 to 5 hours of continuing education. That goes towards the 8 hours of continuing education that you're required to have every 2 years. So it's another wonderful benefit. And additional information is also available on our website. But with that being said, once you complete the 40-hour program, then do 100 treatments, then observe 100 treatments as audited by a professional, and then complete the certification examination to become a professional, now you can attain registration as the highest level laser hearable technician in the state of Texas. So it's not too difficult by any stretch of the imagination. And that, of course, is individual registration. And that allows you to perform laser hair removal treatments in a registered facility. Alright, so what do you have to do to become a registered facility? Well, there's 5 things. First, in order for a facility to be registered, they must first have a professional technician assigned to that facility. Now, a professional technician is only able to be a professional technician for one facility. So if you as an operator have more than one facilities, you're going to need more than one professional technician. Now, if you don't have a professional technician in your registered facility and you lose that individual, if they were to resign and go elsewhere, you have 45 days to replace them before having to cease your operations. So having a reliable professional technician is very important to a successful business. That's the first requirement. The second requirement is that of a consulting physician. The consulting physician must be an individual that is in good standing with the Texas Medical Board, so they must be an MD or DO, licensed to practice medicine, whose primary clinic is within 75 miles of your practice location. The consulting physician's main duties are essentially threefold. 1, to come up with, in tandem with the facility owner, the treatment protocols and procedures to be adhered to in the performance of laser herbal treatments. 2, to be reachable in the event of an emergency, to be able to conduct quarterly audits. So every 3 months, the physician must come in and audit the clinic, and to ensure that essentially the protocols and procedures as set into place between the facility operator and the physician are being adhered to. A pretty simple audit. The physician actually can delegate that audit, but we're going to talk a little bit about that more later. So that's the second thing. So your first thing is a professional technician. The second thing is your consulting physician. The third item that you need is a designated physician. Your designated physician is a physician who, like your consulting physician, is within 75 miles of your practice in good standing with the Texas Medical Board to practice medicine in the state of Texas, but who is reachable in the event of an emergency when your consulting physician isn't reachable. So it's just a backup physician. The state of Texas wants you to have 2 physicians that you can contact. Your consulting physician, if they're not available, if he or she is not available, then you can always fall back on your designated physician. Otherwise, the designated physician doesn't have to provide quarterly audits, doesn't have to sign the contract that needs to be on file with DSHS. So it's really a position that does not involve a lot of activity. The fourth thing, you must have a laser safety officer. Now the Texas Laser Institute, through our 40-hour program, will certify you as a laser safety officer, grant you a certificate, which is all that is needed to become the LSO for your facility with DSHS. And then finally, the fifth thing is a payment to DSHS in the amount of $1,260. And those are the 5 things that are required in order to register a facility in the state of Texas. Again, a professional technician, a consulting physician, a designated physician, an LSO, and then finally payment of $1,260. You will submit all those with your application to DSHS alongside the contract that you must sign with your consulting physician to register your facility. Now that contract by law is required to have certain things within it, and DSHS has done a nice job of providing a model contract or a boilerplate version of that contract on their website. And I certainly encourage you to look at that as at least a starting place to go to when drafting your own consulting physician contract. Because again, if it does not have those elements, DSHS will not register your facility, send it back to you, and for you to redraft that contract with your physician. Alright, so now we've talked about what you have to do to become registered in Texas in an individual capacity, as well as what you'll need to do in Texas to register your facility. Now just a minor point. Your facility registration is that. It stays with the facility forever. It's good for 2 years, and every 2 years you need to renew it for $1,260, but essentially that facility application stays with that facility. It's important for facility owners to understand that the individual registration goes with that individual. I've had a lot of facility owners contact us and say, hey, I've paid for that individual to go through the course or for the registration fees, and then they left to go elsewhere. They had to understand that that registration also leaves with them. They're not able to retain that. That's their registration, right? So that being said, we have the individual as well as the facility registration. Alright, so what are the facility requirements? So as a registered facility, you must be, of course, registered with DSHS, and the facility is required to have certain things on site. First, you must have the danger sign. We deal with, of course, Class 3B and Class 4 FDA-approved medical devices. And the what's called nominal hazard zone, or the room in which the laser system is being operated, must be demarcated as such. So you're going to be required to have warning signs on the outside of that dangerous or the nominal hazard zone. Those warning signs are very well defined within state statute as to what they must show. You must have the word danger, not in any word, must be the word danger, D-A-N-G-E-R, encircled in red, and then enclosed with black. The correct warning language must also be displayed on the sign. The warning language gives folks that are entering that nominal hazard zone, a notification that that laser system imposes hazards to the skin and to the eyes. You must have specifications as to the laser system that's also in the room. So what are the characteristics of the light? What wavelength? What's the maximum joules that's able to be emitted from the machine? And what's the pulse duration capability of the machine? That also has to be placed on the sign. And then finally, you'll want to have the classification of the laser system, as well as, of course, the symbol of the laser itself. All things must be within that sign. We found that CompliantSigns.com is a very convenient and very affordable way to purchase these signs, and they're only about 10 to 15 bucks a piece depending upon the size. Another requirement, you must have in a conspicuous place. So in a place where folks will be able to see as they're entering or leaving your medical spa, a warning sign. The warning sign must have language and size of at least 26 font with the correct warning and correct wordage as provided by state statute. The language essentially allows people or informs people that laser hair removal cannot be used or is not used for a medical benefit, so we're not practicing medicine, we're not treating a condition, disease, or illness with laser hair removal according to the General Assembly. And also, of course, that it imposes certain risks to the eyes and to the skin. And then finally, it provides a number or a complaint line where individuals can certainly lodge a complaint against your facility directly to DSHS. So again, that must be posted within your facility, and the language for that is actually available on our website as well. Your clients are required to sign a consent sheet. Now, what's unique about a 302 environment, unlike a 301 environment, is that when you're in a 302 registered facility, your clients must receive a copy of that consent sheet. It's a little bit unusual. Again, not a lot of physicians are required to give you a copy of your consent sheet when you go in for a medical procedure or practice, right? Not typically considered to be within the standard of care. But in a 302 environment, not only must they sign a consent sheet, but they must also receive a copy of that consent sheet. State statute also requires that the consent sheet includes at least one thing, and that is danger to their eyes. The General Assembly is very concerned with the danger that lasers possess for one's eyes. Your consent sheet must give warning that it presents a hazard to one's eyes, and as a consequence, they will be required to, at all times while being treated and while the laser system can be in operation, to wear proper safety goggles as supplied to them by you. The next thing, physical inventory audit. We'll talk a little bit about this more in detail in a moment. but you're going to be required to have a physical inventory audit that you take annually. Client charts. DSHS requires you to maintain client charts. The client charts must have certain things within them, which we'll talk about here in a moment. Quarterly audits, we certainly talked about that briefly, and we'll circle back to it again, but your consulting physician is required to audit your facility every 3 months. DSHS is supposed to come out and inspect your facility once every 2 years, so you certainly want to be prepared for that. The inspection is supposed to be random. Of course, posting of registration documents is also required. By what that I mean is, you have to post the registration document in a conspicuous place of your facility. So once you register your facility, the facility will be assigned a registration number, and that document must be posted in a place where your guests can certainly see it. In addition to that, all the individuals at your facility that may perform laser hair removal treatments must also post their registration documents. And just as a heads up, it's very unusual, but DSHS actually places the address, the mailing address, as applied to them on the application of the individual becoming registered with them to perform laser hair removal treatments on your registration document. So again, that document must be posted. So most providers will actually make a copy of that registration document, white out the address, make a copy of that, and then post that up on the wall. And that way the name is showing, but not necessarily the address to which the individual resides. And I think that's a neat safeguard to place at your facility. Now DSHS knows that they certainly can accept that copy of a copy, not showing the address of the individual that's registered in performing laser hair removal treatment. So I certainly encourage you to consider that. And then finally, the facility is required to have at all times, of course, the operating procedures on site for your staff to be able to, or your team to be able to reference. The operating manual of the laser system must certainly be on site, with of course treatment protocols and procedures. So all that must be on site in order for your facility to be within the compounds of the law. The next topic, client charts. Let's go into a little bit more detail here, because this is certainly quite important. The state law requires that you chart all of your treatments. So what are the charts required to have? Well, of course, you have to be able to identify to whom that chart belongs. So you need to have some sort of identification. It can be their name, but some clinics may go ahead for security purposes or for privacy, assign every single individual or every single guest an ID or a number, and then just place that number onto the client chart. That way, if a chart were to go missing, it's just a number, and it doesn't mean a whole lot to anybody unless you have access to the master database, which matches it all up. Some clinics may do that. I think it's probably more commonly seen in some electronic medical record databases, but nevertheless, you must be able to identify to whom each chart belongs. So name is probably the easiest bet. Of course, you need to list the date at which the laser hair removal treatment took place. You must provide on the client chart that they actually received a copy of the consent sheet, and that's very important. Again, remember that every single guest of yours is required to have a copy of the consent sheet. You have to record the name of the technician that performed the treatment on that date. And in addition to that, you have to record the level of registration that technician maintains or possesses. In addition to that, if the treatment, say, were to be produced or performed by a technician apprentice in training, you'd have to have that individual's name, their level of registration, and then on top of that, you'd have to list the senior or the professional technician as well as their level of registration on that same chart. In addition to that, you'll have to be able to provide on every single chart the identification of the laser system on which that laser treatment took place on. So usually the manufacturer, the model number, the serial number of the laser machine, some sort of notation on the chart that gives evidence as to which laser system the treatment took place on is also required. And then finally, of course, your treatment setting. How many joules did you use? What type of handpiece, if you're using an IPL system, for instance, the pulse width, duration, the hertz rate, whether or not what type of cooling or modality that you used. And then, of course, a lot of clinics will also notate if there was pronounced edema, erythema, the client feedback, maybe some notes from the previous treatment settings, and maybe any adjustments that were taken into consideration as a factor from that. So all these things would be a great thing to put into your chart for future reference. And that's your client chart. You'll want to be able to chart those things in such a way where you can print them all. So when DSHS comes out to inspect, they may want to inspect a client chart. The consulting physician is, to the surprise of many, required to also be a professional laser hair removal technician. Now, by virtue of being a physician, they are essentially able to grandfather their way into a senior laser hair removal technician level. So they're not required to take the 40-hour course. However, DSHS does require them to demonstrate some degree of formalized training. So perhaps they attended a CME at one weekend and it was an 8-hour course in lasers, or they maybe even come to the Texas Laser Institute. We have a wonderful 16-hour program, a seminar that they take over a weekend, and it certainly gives them all the tools necessary to succeed as a laser hair removal practitioner, allowing them to easily add it into the practice. But with that being said, they're required to become that of a professional technician to be your consulting physician. So in order to do so, they need to show DSHS some degree of training in laser hair removal, that they perform 100 treatments, that they've seen 100 treatments or supervised 100 treatments, and then they can become essentially a senior laser hair removal technician. So they would submit an application to DSHS with all that information, a check for $100 to essentially become a senior technician. Upon being a senior technician, then they can come to, for instance, the Texas Laser Institute, a state-approved certifying entity, take the professional certification examination, and become a professional technician. The second item, of course, adverse medical events. So the physician is the individual that, of course, is responsible for that phone call. If somebody were to report back to severe blistering, a potential second-degree burn, or a pretty pronounced histamine reaction, or allergic reaction to the treatment, that individual should certainly be referred to the consulting physician so that they can be properly diagnosed and treated. Now, these adverse medical events may be reportable to both the state and to the FDA, and the consulting physician will have to make a judgment call as to the requirements of the regulatory environment in which we operate and the necessity to have to report those events. Of course, we talked about the quarterly audits that the consulting physician must oversee. And then finally, and as interesting as it may sound, a 302 medical spa operator is required to actually purchase a medical system or a laser system on the order of a written prescription. So the FDA limits the sale of FDA-approved medical devices to those that have the ability to write prescriptions. So technically, if a facility owner wanted to purchase a laser hair removal system, he or she needs to be able to do so at the written order of a physician. So the physician would quite literally write down on a script pad to the facility owner as being the patient, one Candela laser system, one Palomar system, one Sagor system, one Suntal system, one LightEdge system, whatever it may be. They need to write down what that laser system is, probably 0 refills, make it good for 12 months, and allow the individual to purchase the laser system at the order of that written prescription. That prescription should be kept on file with the inventory audit. Additional regulations to be mindful of course, no false advertising should take place within your clinic. So be very careful as to what types of claims that you make. Oftentimes we hear on the radio that individuals are promised that they'll no longer have to shave ever again. And that's probably a little bit of a stretch for the vast majority of individuals that have laser hair removal performed. After all, it's not permanent in the sense that as one ages, new hair follicles may certainly grow, albeit not the same as those that we've already treated or destroyed. And then finally, of course, it's not likely that 100% of the hair will respond in 100% of all individuals. So with that being said, those are two very good reasons as to why a practitioner should never make the claim that an individual will never have to shave again. So be careful of your advertising. Another point, that under Rule 289-301, registration for the use of lasers for purposes other than laser hair removal should be considered. So if, say for instance within your 302 clinic, you're also using an IPL machine, well, rather an IPL machine with a handpiece that allows you to use it as an NDI laser, or a fractional laser such as a Palomar system, or maybe you have some Q-switch laser systems in your clinic for tattoo removal and the treatment of certain pigmentation or pigmented lesions. Those individual systems are really under a 301 environment, not a 302 environment, as 302 only speaks to laser hair removal. So if you are using laser systems for something other than laser hair removal, and it's a Class 4 FDA-approved medical device, you'll need to register your facility under Rule 301 as well. 301 registration is very simple, straightforward, and easy. It's only $230. It's a very simple application process, and I certainly encourage you to do it. Another consideration, treatments for indications other than laser hair removal should only be done by the order of a written prescription. So Rule 302 limits the practitioner's scope to just that of laser hair removal. As soon as you take a light-based system or device and use it for anything other than laser hair removal, you are to do so only at the written order of a physician. So a very important concept to wrap your hands around. A lot of times folks ask me, well, what is the regulation as it pertains to IPL photofacials or tattoo removal? Well, 302 is going to limit your scope of practice to just that of laser hair removal. So can you perform an IPL photofacial for the treatment of rosacea, telangiectasia, spider veins, or perhaps even tattoo removal with the Q-switch system? Well, 302 certainly suggests that you may, but in order to do so, you need to do so underneath the direct delegated order of a physician. And that certainly embodies a lot of considerations to which further discussion will be needed. Another consideration, receipt for possession, disposition of laser system, as we already talked about. Once you take delivery of your laser system, you need to have some documentation that shows when you took delivery of it. That documentation should certainly be filed away and probably pretty close to your typical inventory audit. Obviously, if you're to sell your laser system or transfer ownership of it, record of that would also be necessary. I encourage you to consult with a lawyer anytime you actually purchase a laser system or dispose of a laser system, as a proper legal contract showing good title should certainly be considered, with certain considerations as it pertains to liens in particular, as well as having a bill of sale. So certainly legal consultation, I think, could go a long way when purchasing a rather expensive investment or even selling a laser system. And then finally, of course, report a theft of IPL laser systems to DSHS. Just remember by law that you are required to report to DSHS if in the event that one of your laser systems or IPL machines were to ever become stolen. So, very important, remember that anytime you take possession of a laser system, you need to have a receipt showing when you took possession of that laser system. And then finally, of course, if you were to dispose of it or transfer ownership of it, you need to have some sort of documentation in place that shows evidence of you doing so. Very important for property tax considerations, but in addition to that, it's very good practice to have. If you were to make a purchase of a laser system, particularly on the secondary marketplace, I strongly encourage you to do so not through the contract that might be put in place between you and a broker, but rather one that is drafted by you and a lawyer. Very, very important, particularly when purchasing a laser system, as you certainly want to have certain representations made to you. And perhaps just as important, when you are selling a laser system, so that you know that you can transfer good and effective title and that you limit your representation or the warranties that you may otherwise place upon that system. So again, I encourage you to contact a very knowledgeable business lawyer that's good at contract drafting for the sale or disposition or even the purchase of your laser platforms. And then finally, don't forget, if it were to happen, you'll certainly want to reach out to DSHS and inform them if ever the event that your laser system were to be stolen or go missing. And that is, as a whole, is a very nice overview of the regulatory environment in Texas. I hope that you found this to be very informative. Of course, if you have any questions, I encourage you to contact us. We can be reached at 832-767-0977. You may visit our corporate headquarters here in Houston, Texas, our secondary location in Dallas, Texas, and of course we have partnership locations around the world. Again, my name is Robert Logue, and it's a pleasure being able to speak with you today. Thank you very much.